Now let's talk about terms implied in custom or by custom. I expect this to be a very short video because really it's building on what's gone before with the terms implied in fact and terms implied in law. Basically, terms are implied by custom or trade usage. That the implication of these terms occurs where the terms are well known, uniform, reasonable and certain. A key case in this area is Constant Industries and Norwich Winterthur Insurance. Facts of that case pretty straightforward. Back in 1976, Constant engaged a company called Bedford Insurances as its broker to arrange insurance for general business. Bedford selected the firm Norwich as the insurer, and Constant and Norwich were the parties to the insurance contracts. Constant paid the insurance premiums pursuant to the contracts to Bedford for ongoing payment to Norwich, but Bedford actually didn't pay them on to Norwich and was subsequently wound up. So Norwich sued Constant for the unpaid premiums. Under the terms of the insurance policies, Constant was obliged to pay the premiums to Norwich, and Bedford wasn't Norwich's agent. He wasn't actually authorised to collect the payments on its behalf. Constant argued that there was an implied term by virtue of custom in the insurance industry that the broker alone is liable to pay the insurer for the payment of the premium, or alternatively, maybe that the payment of the premium by the insured to the broker discharged the insured's liability to the insurer. Constant also argued that an implied term is necessary to give business efficacy to the contract. So, what basically happened? The test, in fact, the test is appearing on the slide now, but I'm going to take you into the next slide because I think that this probably explains it or summarises it better. So firstly, what we need to do is ask ourselves whether, as a matter of fact, this term that is seeking to be implied is in fact a custom. So the existence of custom or usage needs to be, as a matter of fact, something that will justify the implication of a term into the contract. Secondly, the term needs to be notorious. While it need not be universally accepted, there must be evidence that the custom relied on is so well known and acquiesced to in the industry that everyone making a contract in that situation can reasonably be presumed to have imported that term into the contract. Thirdly, the term must be used in a consistent way. A term won't be implied into a contract on the basis of custom where it's contrary to the express terms of the agreement. And lastly, it doesn't actually matter whether any of the individuals to the particular contract had any knowledge of it. If it is in fact a term that's implied by custom, if it meets those other three tests, then the actual subjective knowledge of the individual contracting party won't be relevant. So in the case of Constant, the question of fact, the notorious nature and consistency, those tests were not met and that contract term was not found. So it might be argued that a term is implied by custom on the basis of some entrenched norms in a particular context. So a good example of this is this idea of going to the baker and asking for a baker's dozen. We know that a baker's dozen, as a matter of our context and culture, means 13 rolls. I have to say, every time I go to Baker's Delight, I don't get 13 when I order a dozen. I must actually try to say baker's dozen. But that's just an aside. It's very difficult to prove that a term ought to be implied by custom. It's either implied by custom as a matter of fact or it's not. So have a look at Constant. It's in your casebook at chapter 14, section 60. And I think that you'll find that that provides you with a really good overview of how terms implied by custom work. In the next very quick video, I'm going to just sum up how terms implied in fact, custom and law overlap, work together. I look forward to seeing you there.